Alright, third and last part of this preliminary crap in regards to ESV Austria. This is the full judgment, at least section 5 of the full judgment. This details the entire case from beginning to start, including procedure, relevant legislation nationally and internationally. Make some reference to some precedents, which I will start looking into as soon as I have managed to get through this right here. We may have to do it in several parts. On account of it being rather long, it's 23 pages. All the information here has already been given elsewhere, but there's some info in here that's not anywhere else. So, we shall start at the beginning. In the case of ESV Austria, the European Court of Human Rights, 5th section, sitting as a chamber composed of Angelika Nussberger, André Poczynski, Siofa O'Leary, Martin Smits, Gabriele Gusko-Stadelmaier, Letif Yusenyov, Lado Chanturia were the judges. It's apparently the 5th section of the court, not 5th section of this judgment thingy-majig. Very clear. Having deliberated in private on the 2nd of October 2018, delivers the following judgment, which was adopted on that date. First, we're getting into procedure. A case originated in an application against the Republic of Austria, lodged with the court under Article 34 of the Convention for the Protection of Human Rights and Fundamental Freedoms, hence to refer to as the Convention, by an Austrian national, hence referred to as the applicant, on 6th of June 2012. Speedy, 6 fucking years that took apparently. President of the section granted the application anonymity of the court's own motion, Rule 47, subsection 4 of the Rules of Courts. 2. The applicant was represented before the court by Genef Rami Sommer, a law firm based in Vienna. The Austrian government, were represented by their agent, Ambassador H. Tichy, head of the International Law Department at the Federal Ministry for Europe Integration and Foreign Affairs. The applicant complained that her criminal conviction for disparaging religious doctrines had violated her right to freedom of expression under Article 10 of the Convention. On 16 September 2015, the complaint concerning the alleged violation of Article 10 of the Convention was communicated to the government, and the remainder of the application was declared inadmissible, pursuant to Rule 54, subsection 3 of the Rules of Courts. A third-party observation was received from the European Centre for Law and Justice, which had been given leave by the President to intervene in the written procedure. And then the facts. From here on out, it starts getting a little bit more interesting. So, applicant born 1971, lives in Vienna. From January 2008, she held several seminars entitled Basic Information on Islam at the right-wing Freedom Party Education Institute. The seminars were open not only to the members of the Freedom Party or invited guests, but were also publicly advertised on its website. In addition, the head of the Freedom Party, HCS, had distributed a leaflet specifically aimed at young voters, advertising them as top seminars in the framework of a free education package. The applicant had not been involved in the selection of participants. 2 of these seminars were held on the 15th of October and 12th of November 2009 with around 30 participants at each. One of the participants was an undercover journalist working for a weekly journal, and at the journal's request, a preliminary investigation was instituted against the applicant, and on the 11th of February 2010, she was questioned by the police concerning certain statements she had made during the seminars, which had been directed against the doctrines of Islam. On the 12th of August, the Vienna Public Prosecutor's Office brought charges against the applicant for inciting hatred pursuant to Article 283 of the Criminal Code. Hearings were held on the 23rd of November 2018, 18th of January 2011, and the 15th of February 2011. At the hearing of the 18th of January, the Regional Criminal Court informed the applicant that the legal classification the court might adopt in the matter could differ from the charge. The hearing was therefore postponed to give her time to properly prepare a defense. At the end of the hearing of 15 February, the regional court acquitted the applicant in relation to several of the statements originally included in the indictment under Article 283 of the Criminal Code. The reason was partly that the public prosecutor withdrew the indictment concerning certain statements, and partly because it could not be established that the applicant had made some of the other statements exactly or at least roughly as they were written in the indictment. She was, however, convicted of disparaging religious doctrines pursuant to Article 188 of the Criminal Code concerning 3 remaining statements. She was ordered to pay the cost of the proceedings and a day fine of €4 for a period of 120 days amounting to €480 in total, which would result in 60 days imprisonment in the event of default. So the cost of the proceedings is one thing that often doesn't get mentioned. It's pretty standard clause when you're fighting the government for something, that if you lose, you have to pay for the fight. Pretty common, not necessarily something to raise much of a fuss about, but the fact that they don't mention this, I mean, she has to pay a €480 fine, but the cost of the court proceedings, that's several times that amount at the very least. That's at least a couple of €1,000 that you gotta pay. I mean, I can't make a real good estimate of how much this is, but I mean, if somebody were to tell me 10,000, I wouldn't be surprised. It wouldn't be like, nah, you're full of shit. I could look into this a little bit more, but probably should and will, but just found it interesting how that often doesn't get mentioned. It doesn't really get mentioned in the it's pretty normal that when, for instance, the European Court of Human Rights says, oh yeah, they gave a punishment that was on the lighter end of the potential punishment spectrum that they could lay down, they conveniently forget to mention that this entire thing that they already had to pay for the court proceedings. And I wouldn't be surprised if, since she appealed, 2 or 3 times in her own nation, those court proceeding costs would also be incurred by her. And they have a legal reason not to include that, because it's basically a standard clause, not really part of her punishment, just the consequences of not winning the case. But it's convenient, isn't it? Very convenient, I'd say. So, to continue, the court considered the applicant's repeated infringement as an aggravating factor, and as a mitigating factor that she did not have a previous criminal record. The court found her guilty of publicly disparaging an object of veneration of a domestic church or religious society, namely Muhammad, the Prophet of Islam, in a manner capable of arousing justified indignation. The statements which the court found incriminating were the following. And this is really, really bad. I'll read the English translations naturally. One of the biggest problems we are facing today is that Muhammad is seen as the ideal man, the perfect human, the perfect Muslim. That means that the highest commandment for a male Muslim is to imitate Muhammad, to live his life. This does not happen according to our social standards and laws, because he was a warlord. He had many women, to put it like this, and liked to do it with children. And according to our standards, he was not a perfect human. We have huge problems with that today, that Muslims get into conflict with democracy and our values system. Continued. 2. No. First of all, I mean, how is, the thing that they took issue with here is the statement, he liked to do it with children. That is 1/3 of their fucking case. Here, in between all of this, which is all true, at the very least, I mean, you can't say that any of these things is not a statement of Islamic doctrine as most Islamic sects put it forward themselves. Then she just adds, he liked to do it with children. I mean, could you word that more objectively? Probably. He has been known to have, I mean, but how in the hell is that the basis? I mean, you can say you can make a judgment about that statement in whatever way you want to, but the very fucking concept that the law needs to get involved here, that somebody found it necessary to start a fucking police investigation around this. I mean, what the hell is wrong with these people? I'm trying to. It's very difficult. So if anybody that sees this is from Austria or has a bit less of a language barrier when it concerns Austria, because my German is absolute shit, and I don't know. Well, I hardly know the first things about Austria. I would very much like to know or have an inkling about which weekly journal sent out that journalist, or didn't necessarily send out that journalist, or which weekly journal started this police investigation or asked or requested this police investigation. Because I would very much like to know if and how they benefited from this. Or if it's just, or if this is just another little aside. Oh yeah, look, we can do some damage to our political opposition this way. Which is not what you're doing. They potentially did immense damage to the whole legal framework, and they once again pointed out how fucking useless the concept of human rights when applied in this positive way is. But this isn't going to help their case. This is going to piss people off, and more than a little bit. This isn't going to cost the Freedom Party anything. On the fucking contrary. It's like they want their old enemy back. And they just won't stop pushing. Until they finally manage to get the fucking Nazis back. You must really miss those guys. I don't miss Nazis. Not whatsoever. I mean, when I hear the word ethno-state, I still die a little inside. I'm like, nah, not this shit again. Or every now and then when you meet a normie that doesn't understand the concept of an ethno-state, you have to explain the concept of an ethno-state to them, and just to point out how stupid and shit it is. And even when I have to do that, I'm like, oh, nah, I have to explain the concept of an ethno-state, which means I have to talk about it, think about it, and that sucks. Oh. Alright, I'm going to quit my bitching and continue on. 2. The most important of all hadith collections recognized by all legal schools. The most important is the Sahih al-Bukhari. If a hadith was quoted after Bukhari, one can be sure that all Muslims will recognize it. And, unfortunately, in al-Bukhari, the thing with Aisha and child sex is written. Statement number 2. Apparently those two were part of the same statement, according to them, or something. And this one is part of the second statement, or whatever. I remember my sister. I have said this several times already. When SW made her famous statement in class, my sister called me and asked, "For God's sake, did you tell SW that?" To which I answered, "No, it wasn't me, but you can look it up, it's not really a secret." And her, "You can't say it like that." And me, a 56-year-old and a 6-year-old. What do you call that? Give me an example. What do we call it if it's not pedophilia? Her, well, one has to paraphrase it, say it in a more diplomatic way. My sister is symptomatic. We have heard that so many times. Those were different times. It wasn't okay back then, and it's not okay today. Full stop. And it's still happening today. One can never approve something like that. They all create their own reality because the truth is so cruel. I mean, I'll grant you that this woman doesn't really come across as the most reasoned, rational, or, a lot of what she says comes across as emotionally tinged. Sure, I probably wouldn't like listening to it, but here she's talking about a phone conversation that she had with her sister, in which her sister said, "Oh yeah, but you can't just call Muhammad a pedophile. You have to paraphrase it, you have to word it in a different way, because otherwise you might piss people off." Isn't it ironic? She talked about that during her damn seminar. How prophetic. How prophetic. And can you imagine having this shit? I mean, the investigation started in 2010. It's 2018 now, and it still isn't completely over. It's 8 fucking years. Can you imagine 8 years of your life being spent? And it's a significant amount of time and money and effort and energy being spent in fighting this shit, in having to justify yourself in front of these fucking courts, in having to figure out what. Because I mean, you have a choice in these matters. For instance, she went to the European Court of Human Rights, but that means that you have to make a claim towards the European Court of Human Rights, and that means you recognize the European Court of Human Rights. And it was a bad move. Well, it wasn't necessarily a bad move, but apparently the move did not pay off in the way that one would have expected it to pay off. And that does mean that she accepted all of it. But by going to the European Court of Human Rights, you have to accept the convention in its entirety, or otherwise you have no fucking business going over there. You know the kind of tools and the kinds of laws and legislation and case law and precedent that they're going to use, and you're basically agreeing to use that tool set. And I mean, by agreeing to use the tool set, you're legitimizing the tool set. I don't really, I mean, that I would feel very uncomfortable with. For instance, if I imagine myself in this woman's position, I'd be like, nah, I ain't going to the European Court of Human Rights. Fuck those guys. That's gonna fuck me a little harder, but then I mean, don't you have to go to the European Court of Human Rights? Because otherwise you haven't fought as much as you could have. You didn't do everything you could to stop that shit in your country, because there was something you could have done and you didn't do it, either because you were afraid or just because you made some kind of judgment, which may very well be correct, but those must be difficult things to grapple with, and to have to do that for 8 years, that doesn't seem to me to be anything to scoff at all. All right, continuing on. The regional court found that the above statements essentially conveyed the message that Muhammad had pedophilic tendencies. It stated that the applicant was referring to a marriage which Muhammad had concluded with Aisha, a 6-year-old, and consummated when she had been 9. The court found that by making the statements, the applicant had suggested that Muhammad was not a worthy subject of worship. However, it also found that it could not be established that the applicant had intended to decry all Muslims. She was not suggesting that all Muslims were pedophiles, but was criticizing the unreflecting imitation of a role model. According to the court, the common definition of pedophilia was a primary sexual interest in children who had not yet reached puberty. So the court can just state, oh yeah, the term pedophilia means a primary sexual interest in children who had not yet reached puberty. And I'm wondering, where is that common? Because it's not common parlance where this is common. It may be common in some little niche form of research on this shit or anything, but when people say pedophilia, they just mean the act. When people in common parlance say or mention pedophilia, they mean the act of having sex with prepubescent children, or just children. Not as in, oh yeah, I mean, this concept, we'll get into this later, and we'll see this later, but the concept of pedophilia that they're making here, once again, makes it so that if I fuck a fully grown woman and a little girl, that I'm not a pedophile, because I don't have a primary sexual interest in those little girls. It's just, you know, why not? Varieties to spice of life, am I right? Alright, because pedophilia was behavior which was ostracized by society and outlawed, it was evident the applicant's statements were capable of causing indignation. No. But then, is it the applicant's statements, or the fact that it is established Islamic doctrine that Muhammad married a 6-year-old, or consummated a marriage with a 9-year-old. Is it the statement about that fact, or the knowing of that fact, that causes that would ostracize Muslims or something? Because it's very unclear here, and I think they purposely leave this in the middle. A lot of times when they say, oh yeah, this behavior, these statements could have led to this, could have led to that, they're not clear. Like, it could have led to religious intolerance, and we're talking, it's like they want you to assume that they mean, oh yeah, the larger part of Austrian society would quit being tolerant of Muslims, but something about the way they're phrasing all this, the way they are putting all this forward, the way they're speaking about this and tiptoeing around certain things, makes me think makes this reek of that doublespeak, you know? They want it to seem like they're saying, oh yeah, but we don't want to create any more fucking bigots. But on the other hand, it seems like they're saying, oh, we don't want Muslims to riot. And I'm like, come on, man. If people are going to write about a statement like that, I prefer that they write about a statement like that, because then we can throw them in fucking prison or do whatever the fuck you do to people like that, you know? I mean, for fuck's sake. I'd rather know these things. When something needs doing, it's better to do it than to live with the fear of the thing. Better to get on with the doing. The court concluded that the applicant had intended to wrongfully accuse Muhammad of having pedophilic tendencies. Even though criticizing child marriages was justifiable, she had accused a subject of religious worship of having a primary sexual interest in children's bodies, which she had deduced from his marriage with a child, disregarding the notion that the marriage had continued until the Prophet's death, when Aisha had already turned 18 and had therefore passed the age of puberty. In addition, the court found that because of the public nature of the seminars, which had not been limited to members of the Freedom Party, it was conceivable that at least some of the participants might have been disturbed by the statements. So, accusing a subject of religious worship is not okay. Accusing a subject of religious worship of something that is ostracized by society and outlawed, and therefore capable of causing justified indignation is not okay. Saying anything that could hurt anybody's feelings in a public seminar is not okay. It is not okay. If it is conceivable that at least some of the participants in a discussion might be disturbed by a statement, then that statement is no longer okay, because apparently you're infringing upon the rights of others when you're doing that. That's the way it would appear to be in Austria, and it would very much appear as if the European Court of Human Rights has no fucking problem with this. That they're like, you have a wide margin of appreciation and you are using it very well. Motherfucker! No, okay. The regional court further stated that anyone who wished to exercise their rights under Article 10 of the Convention was subject to duties and responsibilities, such as refraining from making statements which hurt others without reason, and therefore did not contribute to the debate of public interest. Who are you to say if somebody has adequate reason to make a statement that might potentially be hurtful to somebody? If I want to make a statement and it could potentially be hurtful to somebody, and I judge that the potential cost that I will bear for that statement, that I will bear for the making of that statement, if I just judge that to be a justified cost towards what I think I might achieve with my statement, then that is my fucking business, and it is no fucking moral busybody or judge or public fucking official's job to get in between that. What in the hell is wrong with these people? How can you put a constraint on freedom of expression that entails not hurting other people's feelings without a good enough reason? That doesn't mean a goddamn thing. That just means you don't have freedom of expression. That just means that flat and fucking simple. Continuing on. A balancing exercise between the rights under Article 9 on the one hand and those under Article 10 on the other needed to be carried out. The court considered that the applicant's statements were not statements of fact but derogatory value judgments which exceeded the permissible limits. So, they are the courts, not the European Court of Human Rights, the regional courts, is drawing Article 9 into this. And Article 9 is freedom of thought, conscience, and religion. How does anybody's right to freedom of religion? How does that curtail Article 10 here? How can this is just sloppy thinking, because if you read the text of these statements, then without all the other case law precedent, without all their other ways of interpreting this, you can't make a link between Article 9 and 10 like that. You can't. You have to do it through Article 10.2, the rights of others. But then when you're referring to those rights of others, they keep referring to the rights of others not to have their religious feelings hurt. And that's not part of your right to religious freedom. That's not part of it at all. Unless you start redefining freedom or religious freedom, or rights even, you know? I mean, once you start redefining this shit, why stop? Why pick and choose? Why not redefine everything? So that nobody knows what the fuck you're talking about anymore. I'm taking a long time for this, aren't I? Oh well. So, continuing on, it held that the applicant had not intended to approach the topic in an objective manner, but had directly aimed to degrade Muhammad. So, the law requires you to approach these subjects in an objective manner? That's a requirement of the law? I can't have my opinions or my thoughts or my feelings about something even? That's not legal anymore? I have to approach this topic in an objective manner? And if I'm not, if I'm not capable, or I don't want to, I should shut the fuck up? So, the court stated that child marriages were not the same as pedophilia and were not only a phenomenon of Islam, but also used to be widespread among the European ruling dynasties. Furthermore, the court argued that the freedom of religion as protected by Article 9 of the Convention was one of the foundations of a democratic society. Inconsequential and inconsequential. Whether or not there were child marriages in the European courts, that does not have anything to do with this. Nothing at all. If I said kiddie fiddlers or 40-year-old kings that married 12-year-old girls and proceeded to fuck them were pieces of garbage. At the very least when it comes to that specific aspect of their life and personalities. I have no problem saying that. Nobody sees these kings as moral figures, as moral guiding figures or anything. So even if we were to somehow say that this fact was relevant, it still doesn't bear any real comparison to what this woman was talking about. They're saying here that child marriages are not the same as pedophilia, which can be said to be true. For instance, you could marry a 12 or a 6-year-old girl for the land titles that she holds or the dowry that will get you, and then proceed to not fuck her until she's 16 or something, in which case you're not really a pedophile. But you did have a child marriage, true, but if it is explicitly mentioned that the marriage was consummated when the child was 9, that is something else, and that would fall under pedophilia as it is understood in the general population. And if these people in these courts are deliberately choosing to use concepts which are completely counter and contrary to the concepts as they are envisioned in the, or as they are understood in the general population, and what are these people doing? I'm not saying they should be guided one for one by these things, but why do you adopt a definition of pedophilia that is that anybody on the streets would say is completely insane? At the very least, if you point out the simplistic flaws in it. I can imagine that if I ask some Joes on the streets, is this definition of pedophilia you agree with a general or primary sexual interest in prepubescent children or sex with prepubescent children, then they might say yes. And if I told you, but wait, wouldn't that mean that if I just, fuck kids on the side, that I'm not a pedophile? Then I say, oh yeah, right, then maybe I don't agree with that definition. Might be worth trying out, but I think that people would look at you pretty weird if you ask questions like that. Not that I generally care, but cost-benefit analysis, not really. And freedom of religion, as protected by Article 9 of the Convention, is one of the foundations of a democratic society, which is very true. But the freedom from religion aspect of that is also excessively important. We can't allow shit like public prayer or blasphemy laws or shit like that, or having to tiptoe around certain subjects because of fear for people's religious feelings. So, we'll continue. Oh shit, I'm gonna have to get more coffee. I thought I might get through this section without having to stop to go get coffee, but I think that might be impossible. Alright, those who had invoked their freedom of religion could not expect to be exempt from criticism and even had to accept the negation of their beliefs. However, the manner in which religious views were attacked could invoke the state's responsibility in order to guarantee the peaceful exercise of the rights under Article 9. Presenting objects of religious worship in a provocative way capable of hurting the feelings of the followers of that religion could be conceived as a malicious violation of the spirit of tolerance, which was one of the bases of a democratic society. The court concluded that the interference with the applicant's freedom of expression in the form of a criminal conviction had been justified as it had been based in law and had been necessary in a democratic society, namely in order to protect religious peace in Austria. So the curtailing of freedom of speech was necessary to protect religious freedom in Austria. No, protect religious peace in Austria. The applicant appealed, arguing that the impugned statements were statements of facts, not value judgments. She referred to several of the documents which she had submitted as evidence which, in her view, clearly confirmed that when Muhammad had been 56 years old, he had had sexual intercourse with the 9-year-old Aisha. She stated that it was no more than reasonable to present those facts in the light of the values of today's society. It had not been her intention to disparage Muhammad. She had merely criticized the notion that an adult had had sexual intercourse with a 9-year-old child and questioned whether this amounted to pedophilia. If one were to follow the arguments of the regional court, it would mean that someone who had married a child and managed to maintain the marriage until a child had come of age could not be described as a pedophile. She further contended that she had not used the term pedophile in the strictly scientific sense, but in the way it was used in everyday language, referring to men who had sex with minors. Whoa! Hadn't even noticed that one before. Apparently, according to this lady, it's men who have sex with minors. Those are the pedophiles. I mean, women who have sex with minors apparently aren't pedophiles then. But all right. Hey, I never said I was a fan of ES. or I agreed with very much that the woman probably believes, but still disagree with curtailing her freedom of speech. Right, she stated she had never said that Muhammad had been a pedophile because he married a child, but because he had sexual intercourse with one. In any event, her statements were covered by her rights under Article 10 of the Convention, which included the right to impart opinions and ideas that offend, shock, or disturb. On 20 December 2011, the Vienna Court of Appeal dismissed the applicant's appeal, confirming in essence the legal and factual findings of the lower court. The regional court based its finding on the facts as submitted by the applicant that Muhammad had married Aisha when she had been 6 years old and consummated the marriage when she had been 9. It had rightfully made a distinction between child marriages and pedophilia. It had not based its finding on an unpredictable definition of the term pedophilia, but on a common definition which was comparable to that used by the World Health Organization. As regards the alleged violation of Article 10 of the Convention, the Court of Appeal, referring to the court's case law, and found that it had to examine whether the comments at issue were merely provocative or had been intended as an abusive attack on the Prophet of Islam. It concluded that the latter was the case, as Muslims would find the applicant's statements, he liked to do it with children, the thing with Aisha and child sex, and a 56-year-old and a 6-year-old, what we call that? Give me an example. What do we call it if it's not pedophilia? Wrong and offensive, even if Muhammad had married a 6-year-old and had intercourse with her when she was 9. So, your statement is not merely provocative, but intended as an abusive attack. If certain people could find your statements wrong and offensive, wrong even if they're true, even if those statements are facts. That's what they are saying here. If you strip away which specific group this is about, and that is what they're saying here. A statement ceases to be merely provocative and becomes an abusive attack when a group would find these statements wrong and offensive even if they were true. What more can I say about that? That is what it says right there. All you have to do is look beyond all you have to do is strip these things of their incidental meaning at this time, and then it becomes clear how shit the principles underlying this stuff are. How completely incomprehensibly illiberal. So the Court of Appeal stated that the reason for the applicant's conviction had not been that the events had purportedly taken place more than 1,000 years ago, and similar conduct would no longer be tolerable, but because the applicant had accused Muhammad of pedophilia by using the plural form of children, child sex, and whatever, without providing evidence that his primary sexual interest in Aisha had been her not yet having reached puberty. So, yeah, we know he fucked a child, but I mean, you can't prove that he fucked her because she was a child, so you're accusing a long-dead semi-historical or religious figure of pedophilia, and that's not okay? What? That's grounds for a criminal conviction that is upheld by several fucking courts? What in the... Alright, moreover, there were no reliable sources for that allegation, as no documentary evidence existed to suggest that his other wives or concubines had been similarly young. On the contrary, his first wife had been 15 years older than him, as could be seen from the documents submitted by the applicant herself. Even if the applicant had had the right to criticize others' attempts to imitate Muhammad, her statements showed her intention to unnecessarily disparage and deride Muslims. So, even if she does not have, according to these courts, the rights to criticize others' behavior. even when they're attempting to duplicate the behavior of a murderous, manipulative cult leader. If somebody were trying to emulate Charles fucking Manson or Jones from Jonestown or shit like that, then and you were saying that might not be that might be completely fucking insane to try to emulate these people, then that would that fall under the same numbers? So you don't have that right. And all this delving into Islamic jurisprudence in European courts, in an Austrian Court of Appeal, in the European Court of Human Rights, what in the hell is this? What does the fact or not, or the story that Muhammad married such or such, or Muhammad's otherwise, what the fuck do those have to do with the fact that you are criminally convicting a woman for speaking? Not even calling to violence, not calling for hatred, not doing any of these things. Just saying something that could maybe potentially hurt somebody's fucking feelings if they're already an authoritarian, closed-minded piece of shit that would throw a hissy fit over something like that. God damn. So harsh criticism of churches or religious societies and religious tradition and practices were lawful. However, permissible limits were exceeded where criticism ended and insults or mockery of a religious belief or a person of worship began. So apparently, according to the Austrian courts and also the European Courts of Human Rights, I can say, oh, I don't believe Jesus such or such, but you can't insult Jesus. So I can't say, well, I think Jesus was a gay-ass hippie. Can't say that. Insulting and mocking. Not saying I think Jesus was a gay-ass hippie for anybody that wants to throw a hissy fit, but just saying I can't say that. It's probably why I can't stop saying it. The interference with the applicant's freedom under Article 10 of the Convention had therefore been justified. As to the applicant's argument that those who participated in the seminar knew of her critical approach and could not be offended, the Court of Appeal found that the public seminar had been offered for free to young voters by the Austrian Freedom Party Education Institute, and at least one participant had been offended as her complaints had led to the applicant being charged. Hey, at least one applicant had been offended, and apparently it was a woman. I didn't notice that before. Her complaints had led to the applicant being charged. So the journalist in question that started this whole shit was a woman, for what it's worth. That narrows down the amount of possible people by 50%. That's a lot. Now, not just a journalist, an Austrian journalist, now it's an Austrian female journalist. Thank you, European Court of Human Rights. So one person being offended is good enough reason to curtail freedom of expression. And all of a sudden I'm having this little flashback. You know, Socrates was forced to drink the poisoned chalice for the charge of corrupting the youth of Athens. The fact that this public seminar had been offered for free to young voters is a problem. Corrupting the youth. All right, I'm going to keep going up till the relevant domestic law, and I'm going to go get coffee. On the 11th of December 2013, the Supreme Council dismissed the request for the renewal of the proceedings. As regards the alleged violation of Article 10, it found that the applicant's conviction under Article 188 of the Criminal Code constituted interference with the rights of freedom to expression, which had, however, been justified under Article 10, subsection 2 of the Convention. Referring to the Court's case law, it held that the aim of the interference had been to protect religious peace and the religious feelings of others, and was therefore legitimate. So the Supreme Court dismissed the request for renewal of the proceedings. It agreed that there was an interference with Article 10, with the right of freedom of expression. However, it considered it to be justified under subsection 2, the cop-out clause, and it held that the aim of the interference had been to protect religious peace and the religious feelings of others, and was therefore legitimate. Interesting. The court has stated many times that in the context of religion, member states had the duty to suppress certain forms of conduct or expression that were gratuitously offensive to others and profane. In cases where the impugned statements not only offended or shocked or expressed a provocative opinion, but had also been considered an abusive attack on a religious group, for example, an abusive attack on the Prophet of Islam, as in the applicant's case, a criminal conviction might be necessary to protect the freedom of religion of others. First of all, an abusive attack on a religious group, for example, an abusive attack on the Prophet of Islam. So an abusive attack on a historical figure equals the abusive attack on an entire group of people, on all the followers of a certain religion. Makes no fucking sense. Makes no fucking sense at fucking all. None. Zero. That is just boom, fucking insane. I mean, it's insane to call this an abusive attack on the Prophet of Islam. To call an abusive attack on what you have called an abusive attack on the Prophet of Islam, to equate that to an abusive attack, no less, on an entire group of people, and then to say that a criminal conviction might be necessary to protect the religious freedom of others. How so? How does that woman's statements how do those women's statements infringe upon the religious freedom of anybody else? Unless you have this strange fucking conception of religious feelings being protected. It's completely bleeping insane. Where a conviction was based on Article 188, the principles developed under Article 9 and 10 of the Convention had to be considered when examining whether a statement was capable of arousing justified indignation. A statement which could not be considered as arousing indignation if it was in balance with Article 9 and 10 of the Convention. What does that mean? I don't know. I don't think anybody fucking knows. The courts therefore had to examine the meaning of the impugned statement as well as the context in which it had been made and whether the statement was based on fact or was a value judgment. Only by considering all of those points could the question of the ability to arouse justified indignation be examined. Applying the above considerations to the applicant's case, the Supreme Court held that she had not aimed to contribute to a serious debate about Islam or the phenomenon of child marriage, but merely to defame Muhammad by accusing him of a specific sexual preference based on the assumption that he had had sexual intercourse with a prepubescent child in order to show that he was not a worthy subject of worship. Not misjudging the importance of the debate about sexual contact between adults and children, the applicant had not contributed to the debate of general interest because she had made her allegation primarily in order to defame Muhammad. On the basis of the regional court's findings that the applicant's statements qualified as value judgments, the Supreme Court held that they had no longer been a contribution to a serious debate. The case had to be distinguished from other cases, blah, blah, blah. In the present case, the criminal conviction constituted a measure necessary in a democratic society within the meaning of Article 10 of the Convention. Moreover, the measure taken by the criminal court had also been proportionate, as the applicant had only been ordered to pay a fine of 480 euros. The Supreme Court's judgment was served on the applicant's counsel on the 8th of January 2014. So, unless you're contributing to the collective, you cannot speak. Your value judgments are of no value to the collective, and therefore you should keep them to yourself. Whatever you say, if they deem it to be not in the public interest or not serving general debate on an important societal issue, then you will not. Then whatever you say does not fall under freedom of expression. And whether you can be criminally convicted for speaking is entirely up to the whim of ideologically infested, moral Puritans who want to seem virtuous, moral and good at others' expense. And with that, I'm going to pause and get myself some coffee.